Madam Attorney General, yesterday, Erez Ruveni filed a whistleblower complaint against the Department of Justice. As I think you know, he was a 15-year veteran of the Department of Justice. He received commendations during the first Trump administration for all his work at DOJ, but he filed a detailed account of his recent experience at the Department of Justice, saying that prior to his determination, that he was terminated after he refused to sign an appeal brief that was unsupported by evidence or the law. And he says, "I didn't sign up to lie." In response to his termination, you made a statement on Fox News a little while ago saying, "At my direction, every Department of Justice attorney is required to zealously advocate on behalf of the United States, and that any attorney who fails to abide by this direction will face consequences." So, General Bondi, I guess the direct question is, he says he was fired because he didn't want to make an untruthful statement to a court of law. I have two questions. Number one, I assume you agree that zealous advocacy does not mean telling untruths to courts of law. And second, if that's not the case, what did you mean by saying he was not a zealous advocate?
Senator Van Hollen, this is all pending litigation, as you're well aware, and the timing of it, I can't discuss pending litigation. This is a whistleblower lawsuit pending within my office, but I will say the timing of it I find suspect, as he takes hits at Emil Bovee, who is one of the best human beings I know, one of the smartest, brilliant men I know, who will soon become a federal judge. And his hearing happens to be today, and I find the irony of the timing of it pretty remarkable, the lawsuit. But this had to do with attorney-client privilege information that was disclosed. I can't talk about the substance, but what I will tell you, and you have obviously my word, any zealous advocacy means to be done ethically and honestly, always. And that's what I mean by zealous advocacy. He also accused Emil Bovee of things that Todd Blanche, who is one of the best human beings I also know, my deputy attorney general, was in the room and said did not happen. But again, I wish I could get into greater detail. I can't because it's pending. But I stand by Emil Bovee and I stand by Todd Blanche every day, and I always will.
Well, Madam Attorney General, I will say that his account seems to have lots of information. So as you say, this will obviously be something that's litigated or reviewed through due process procedures. But I have to say that it's very, very disturbing. We've also heard from others in other departments who are responsible for implementing the laws of the United States that they feel uncomfortable about having been asked to do things that they thought were unethical. Let me go on to some of the budget questions, and I really want to follow up on my colleagues, Senator Moran and Senator Collins. But the DOJ grant funding is being sort of cut back on two fronts. One, in April, the department terminated hundreds of grant awards, notifying grantees that their current grant funds were gone, effective immediately. That included, law enforcement training grants, technical assistance awards, some dating back to fiscal year, I think, 2017. So, question number one is, are you going to be releasing those funds? The second concern regarding grants has to do with the monies that were appropriated in this fiscal year, in March. And my understanding is that DOJ is withholding an overwhelming number of notices of funding opportunities, NOFOs, meaning that grantees who rely on these grants, including many who provide services to victims of crimes, are literally, in some cases, running out of money. For example, the department's biggest grant-making component, the Office of Justice Programs, has only posted one notice for fiscal year 25, no phone notice. So if you could answer the question with respect to both those pieces.
Sure, and that's a very valid question, Senator. The notices will be going out in coming weeks about the grants. And we did cut grants by 6%, and I'm here to tell every senator, if we did cut a grant that you care about that is specific to your state, please contact me. I've turned on grants that were cut off. So please, if that happens, there's an appeal process, but you can pick up the phone and you can call me, and I would be more than happy to look at that. I never want to take away a grant that is actually helping Americans, helping victims, helping law enforcement, and we're looking at it on a case-by-case basis, and many of those are being appealed already, but you have my word, we will look at all of those, absolutely.
Thank you. And in terms of the other piece of the question, when the notices for information will go out, because the fiscal year obviously is, running out, and we are hearing from lots of entities that are waiting for those notices so they can apply for the grant funding.
Yeah, yes, Senator. The notice of funding is consistent with our priorities, and they're finalizing it right now. It will be going out very shortly.
Very shortly. All right. Thank you.
It'll be posted on a rolling basis, too, I believe.
Okay. If you could just keep us posted on that. And I would appreciate it, Madam Attorney General, if you could have your team or respond to a letter that about 30 senators wrote to you on this topic of the prior fiscal year funds that were frozen.
I will make sure they look at that letter. I think we've received probably thousands of letters.
You've gotten lots of letters. But we really do need, in order to do our job, to get responses. Thank you, Mr. Chairman.
Attorney General Senator Van Hollen.
Thank you, Senator. Welcome, Director Vogt. In response to a question that Senator Murray asked earlier about pocket rescissions, you cited a 1975 statement by GAO in the aftermath of a rescissions package that was advanced by President Ford. I think it's important to point out for the record that in the aftermath of the Supreme Court decision in Clinton versus New York, which, as you know, was a line item veto case, where the court said, quote, "There's no provision in the Constitution that authorizes the president to enact, amend, or repeal statutes," unquote. The GAO found that in the absence of congressional action, a rescission proposal would remain just that, a proposal. And that's why GAO later revised its view subsequent to that Supreme Court
Can I speak
decision.
to that, Senator?
I got to go on, Mr. Vogt. If there's extra time and I'm granted it, I'd be happy to have you respond. Would you agree that federal agencies are required to follow the law, including the appropriations law, as Senator Collins referenced?
Yes, I also believe that the president has the ability to run every program as efficiently as possible. And what's interesting about what GAO has said, GAO has changed its view with regard to pocket rescissions. They change their view every administration. What Congress did not do in the aftermath of the legislative veto being struck down is they did not, in fact, change the Impoundment Control Act. Congress has never, knowing this was an issue, has never changed the law.
Mr. Vogt, as I said at the end of my time, if you're given additional time by my colleagues, I'm happy to have you expound on that. But I think what GAO was saying was that the Supreme Court decision in the language I quoted essentially filled the gap in the Impoundment Control Act by making that clear separation of powers argument. But my question was whether or not you federal agencies had to comply with appropriation bills. And one of those provisions is something that I authored that requires OMB to show the American people, American taxpayers, how we are spending their money by requiring OMB to publish the apportionment documents. This is not an optional provision. The system was operating for 3 years. The language is clear. It says OMB shall operate the system, not may, not when it feels like. So, Mr. Vogt, why did you terminate the system given the fact that this is the law of the land?
The administration thinks it's unconstitutional that it gets to the deliberative process and pre-decisional information, the extent to which when a president using his tools at OMB is managing taxpayer money, and many of these are not final agency decisions. The extent to which that is being forced to be reported on a website, our administration believes that that's unconstitutional.
Oh, do you have a legal opinion expressing that
We
view?
certainly have transmitted from the Department of Justice the views as it pertains to this. Our general counsel has articulated our grounds for this opinion.
Mr. Vogt, I think given the fact that it's a congressional provision that was put in there by law, it was also enacted, signed by previous presidents, it is the law of the land. I have not seen any memo from the administration declaring it unconstitutional or the grounds for it being unconstitutional. So I welcome providing that. I want to get to another issue regarding the GAO, because as you know, they found that the administration was illegally impounding funds from 2 accounts, and that there are 36 ongoing investigations about other withholdings. I've heard what you had to say about GAO, and I'm not going to ask you to repeat your views about GAO, but what I want to know is whether or not you plan to spend the dollars that were appropriated for the state electric vehicle infrastructure deployment plans and the Institute of Museum and Library Services programs. Simple question. Are you planning to spend those monies as required?
You know, it's interesting thing about GAO is they never had an issue with regard to President Biden not withholding funds with regard to the border
Mr.
wall.
Vogt, I just
They
asked
change
you a
their
question.
position constantly.
Are you planning to spend the funds?
We're going
that
through
were-
a programmatic review. We will look at our options under the law with regard to that funding. Each set of funding is different, as you know, and we will be continuing to evaluate that program. The GAO is improperly calling programmatic review impoundments. They've now done it, I believe, 2 times. I expect them to do it many more times, and it will not
That
change
is
the
why
reality that these are not impoundments.
That's why you're answering a different question, right? I didn't ask you to comment on the GAO rationale. I happen to agree with their rationale. You disagree. I asked you a much more simple question. When do you plan to spend these funds? Do you plan to spend these funds before the end of the fiscal year?
Your question, the GAO statement was the predicate for the question. I didn't feel like I can answer the question without dealing with the
I'm
predicate.
just going to ask you a straight question with no predicate. Do you intend to spend the monies that were appropriated by the Congress for these 2 programs?
We are considering the programmatic aspects of that program. We know that we have options under the law, including a potential rescissions bill. We have a lot of different things that we can look forward to with regard to how we might approach those fundings, various statutory ideas, and we will take a look at all of the tools that are on the table for the purposes of those funds. But we're not ready here to say that we are done with our programmatic review, and GAO, quite frankly, is improper to continue to call it an impoundment.
Well, we have a difference of opinion on that, but my question again was this
time
issue
has
about spending the
expired.
money, and Madam Chair, I appreciate that, and I'm going to follow up with you directly because I know you asked questions about whether or not the administration was required to apply appropriations law, which I think we both agree it is, and we obviously have a difference of opinion here, so I look forward to following up with you.
Thank you. Senator